Hey YouTube family and GN subs, it's Humberto from GrayLaw TV. You know what I do on this channel is I take a very complicated subject matter, I break it down, make it simple to digest. This is one of those videos. It's called Automatic Conversion of Family Preference Petitions. You can lose a substantial amount of time on your petition if you do certain things, marriage and divorce, petitioner becoming a US citizen, or simply aging out. So I'm gonna break this stuff down so you don't make the mistakes, that a lot of people make. You're not gonna find this kind of information on other channels, folks. So the law on automatic conversion can be found at 8 CFR 204.2. There's also two cases that are really important, matter of Wang and matter of De Osorio. These two cases simply state that as a matter of law, automatically certain preference categories convert to other categories. There's nothing you really need to do other than provide immigration with notice, and we'll talk about what you do in those instances, okay? So the law is pretty straightforward. So the complicated part, how does this stuff break down? I'm gonna go through how cases convert, okay? First preference case, unmarried sons and daughters of US citizens can convert to the third family preference category when the beneficiary marries. 2A category, unmarried sons and daughters of permanent residents. Petitioner becomes a US citizen, goes up to the first preference. Beneficiary turns 21 years of age, it goes down to the second preference category, 2B, unmarried sons and daughters of permanent residents over 21. 2B category, unmarried sons and daughters of permanent residents who are over 21. If the petitioner becomes a US citizen, it goes up to the first preference automatically. You can see by operation of certain things happening, aging out, marriage, divorce, okay? These things happen automatically, these petitions can be affected. So let's look at the Visa Bulletin. Now this stuff is gonna get real. Now you're gonna see exactly why you may opt to do certain things and stay in certain categories because you can lose a lot of years, okay? So if you are in the first preference category and you marry, you move to the third preference category. Look at the difference in time of adjudication, right? So in some instances, if you're close to getting that visa, you do not want to marry, you're going to wait a lot of time. You'd rather get your green card, then marry your spouse. Look at the second preference category, it's current. You're gonna save a lot of years. If you marry and go to the third preference, look at the difference. It's 6-year difference. All right, let's look at the Visa Bulletin here. Second 2B category, right? Unmarried sons and daughters of permanent residents. Petitioner becomes a US citizen, goes to first preference, right? Look at the difference in time. Not so substantial, but still, if you could save a year, you save a year, right? Petitioner can hold off on becoming a citizen, so you can save time. And what you do is you can opt to stay in the 2B category because it's going to be faster, or whatever category is faster. Sometimes it's 2A, unmarried sons and daughters, petitioner becomes a US citizen, it goes to first preference, longer wait. So you can opt to stay in the 2A category. I recently had a case where the mom was a permanent resident. She applied for her two sons who were then under 21 years of age. So she becomes a US citizen, okay? What happens to these cases, all right? When she becomes a US citizen, the law is very specific. You look at the child's age at the time the petitioner becomes a US citizen. That's a nugget that you're gonna really, really pay attention to on this video, okay? So at the time petitioner becomes a US citizen, one son was 19 years of age, he was fine. So his 2A petition elevated to an immediate relative petition, still able to get his green card. So the second son was over 21 years of age at the time his mom naturalized. Now, the interesting part of this case is that we've done previous videos on CISPA, so his CISPA age, the Child Protection Act, was actually 19 years of age, which kept him in the 2A category. So 2A category then, when mom becomes a citizen, converts to the first preference category. 2A category current, First preference category, not current. So what we did is we opted out. We opted to stay in the 2A category, all right? Things to look out for. When you are in the second preference category, 2A or 2B, and you marry, guess what? Petition gone, automatically revoked. You lose your petition. So if you're in the second preference category, do not marry. Operation of divorce. So if you're in the third preference category, you get a divorce, you go to the first preference category. Again, big time difference. My clients actually divorce so they can get the green card faster in the first preference category. They get the green card, they remarry, apply for the spouse in the 2A category current. Nothing wrong with that. You can do it. It can happen, just saves lots of time, lots of years. Again, we talked about this before. The petitioner becomes a U.S. citizen. It can be substantial changes in your petition. Make sure that you study this stuff before the petitioner becomes a U.S. citizen, okay? All right, let's talk a little bit about notification, what you need to do. The beneficiary, not the petitioner, the beneficiary needs to write a letter to say that they are opting in or out of a certain category, okay? It's a simple letter, all right? Where do you send it to? You send it to either USCIS if your case is still there. You send it to NVC if your case is at the NVC, or in some instances, your case is already at the consulate. That was my case. My clients were already had their interview was going to be scheduled like in 30 days, and the mom got her citizenship 15 days prior to their interview. All right, so the beneficiary, we gave the letter to give to the consulate that they wanted to opt in to a certain category, okay? Now, what do you need to put in the letter? To whom it may concern, my petitioner just became a U.S. citizen. However, I do not want to go to the first category. I opt to stay, in the 2B category. It's that simple, right? If your case is at the consulate and you send it to the consulate then must send an email to USCIS, notify them that you're opting to stay in a category or opting out of a certain category, okay? That's how it works, folks. Hey, thanks so much for watching GrayLaw TV. Click below, like and subscribe. Give me a thumbs up. Ring the notification bell. I'll notify you when new content is coming. Courtney's coming at you with some great new videos. Thanks again. See you soon.